Hey guys, and welcome back. Today we will be discussing mistake of fact and mistake of law under Indian Penal Code. The basis of this differentiation lies in the maxim ignorantia lex non excusat, ignorantia facti doth excusat, which means that a mistake of law is not excusable and a mistake of fact is excusable. Let's take a look at the sections first. So let's start with section 76. It says act done by a person bound or by mistake of fact believing himself to be bound by law. So such acts which are done by a person who are either bound or who by mistake of fact believe themselves to be bound by law. Nothing is an offense which is done by a person who is or who by reason of mistake of fact and not by reason of mistake of law in good faith believes himself to be bound by law to do it. So if a person is actually bound by law to do it, it is not an offense. Not at all, not to start with, right? But even if he by mistake of fact in good faith believes that he is bound by law, that he should do it, that the law requires him to do it, and he does an act, then that is not an offense because it was a mistake of fact, and mistake of fact is an excuse, but mistake of law is not an excuse. So let's see the examples. The illustration A says that a soldier, fires on a mob by the order of his superior officer in conformity with the commands of the law. A has committed no offense. So in this case, A, who is a soldier, is bound by law to do this act. So it is not an offense. So it is not an offense because he is bound by law to do it. The second illustration says that A, an officer of a court of justice, being ordered by the court to arrest Y after due inquiry believes that Z to be Y, arrests Z. So he makes a mistake and he arrests the wrong person. However, he believes that he is bound by law to do it, and there is a mistake of fact. There is not a mistake of law. He did not misinterpret the law. There is a mistake of fact. So he believes that Z is Y and he arrests the wrong person, and he did do some due inquiry. He did try to find out whether this is the person who he is trying to arrest. So this shows good faith, and because he in good faith believes that he is bound by law, it is not an offense. So the crux is that either a person is bound by law to do it, then he does an act, then it is not an offense, or he by mistake of fact believes in good faith. Good faith is the most important part. He believes himself to be bound by law to do it in good faith. Good faith being the operative term. That's the most important part, that he should believe in good faith. Otherwise, it's an offense. So, similarly, section 79 says that act done by a person justified or who, by mistake of fact, believes himself to be justified by law to do it. So, the section says that nothing is an offense which is done by a person who's justified by law or who, by reason of mistake of fact, believes in good faith that he is justified by law in doing it. So let's take a look at the illustration of this section. It says that A sees Z commit what appears to be a murder. A, in the exercise of best of his judgment, exerted in good faith of the power which the law gives to all persons of apprehending murderers, in the fact seizes Z in order to bring Z before proper authorities. A has committed no offense, even though later on it may turn out that Z was acting in self-defense. So this person A, he goes somewhere, he sees that another person Z is committing a murder. He is like, I am a good citizen, I should arrest him. It is the power given by law to every citizen. I should arrest this person who is committing a murder. And he in good faith believes that I just saw this man committing a murder. So there is good faith involved, and he arrests Z in that good faith. So he has committed no offense because there was good faith, there was mistake of fact. The mistake of fact is that he later on finds out that this Z person was not committing a murder. In fact, he was acting in self-defense. Even though he arrests Z, he did it in good faith due to mistake of fact, and he believed that this is justified. This is justified by law for me to arrest Z. So, the crux of section 79 and 76 and 79 is that a person is either bound or justified by law to do it, that it is not an offense, or this person believes that in good faith he is bound by law to do it, that he must do it, or he is justified by law to do certain act, and then if he does it, it is not an offense. A common PT question which comes is that a hangman who hangs people, under what section is he given a defense? So why is he not responsible for committing murders? Because he's hanging people. Why is he not a murderer? The reason for that is that his act is an exception which falls technically under both section 76 and 79. He's also bound by law to do it, and he's also justified by law to do it. But if in the PT you have just one option, there is no double option of 76 and 79, you have to tick just one section, you have to make a tick at just one section, then the hangman will fall under section 79. So remember this for the PT exams. Now let's take a look at some of the case laws for further elucidation. State of Orissa versus Ram Bahadur Thapa. It is a 1960 Orissa High Court judgment. Now Thapa was a Nepali servant or help who along with his master was walking through the forest. They saw a person approaching and they tried to figure out if it was a ghost, if it was an apparition, or if it was a human being. It was night time and they believed in ghosts, especially the servant, the Thapa, who was with the master. He believed in ghosts and they shot this person dead. In this case, it was held that it would fall under section 79. As it was mistake of fact, they mistakenly believed a human being was a ghost, and believing the human being to be a ghost, they struck the human being and the human being fell dead. So they were justified by law. I understand that a lot of you might be appalled and be, how is this possible? But let's just hear the case out and we'll discuss how we can interpret this case in the current circumstances. The decision in this case was basically based on prior two cases. That was Varyam Singh versus Emperor, which was a 1926 Lahore judgment, and Boda Kui versus Emperor, which is a 1943 Patna judgment. So in the Orissa High Court, the court said that the benefit, now this is quote unquote, the benefit of section 79 IPC is available to a person who by reason of mistake of fact and good faith believes himself to be justified by law in doing an act, which we've already discussed. The court further said that in view of the clear evidence of the witness in the case, the witness number 29, to the effect that the respondent thought that he was attacking ghosts, he would be entitled to the benefit of that section. Unless from the facts and circumstances established in the case, it can reasonably be held that he did not act in good faith. So good faith, as I told you before, becomes the operative part. Good faith requires due care and attention, which is given in section 52 of the IPC. The court further held that from the circumstances under which the apparition appeared before him, this is the respondent, under the circumstances in which the apparition appeared before him and his predisposition, it would be reasonably inferred that he believed in good faith that he was attacking a ghost and not a human being. There may be slight difference on facts between the cases and the instant case, but on the evidence of the prosecution witness, it is clear that the respondent is protected by section 79. The mere fact that he had exercised extra care and attention, the incident might have been averted, is no ground for denying him the protection of that section. So you can't say that he should have gone a little bit ahead, he should have poked the apparition, he should have found out whether the apparition was a ghost. The fact that he should have exercised extra care is not a reason for denying him the defense. And yes, all of this sounds absurd to us, but understand that this is a 1960 judgment. And it deals with the person, the respondent, the Thapa, the Nepali servant, help in the case, who believed in ghosts, who wasn't very educated. To us in this day and age, it may seem absurd, but you have to take it from the point of view of existing circumstances at the time of the case. And he, in good faith, believed that it was a ghost. The court held in that case that the standard of care and caution must be judged according to the capacity and intelligence of the person whose conduct is in question. The point of this is that you have to judge it from the point of view of the respondent, or the person who attacked, who assailant in this case. The respondent was a Nepali servant who was a firm believer in ghosts. So he was a firm believer in ghosts, and that area, the aerodrome area where this happened, had become notoriously famous for being haunted by ghosts on Tuesday. That were the facts of the case. They saw moving apparitions, and the Nepali servant killed the man. So Section 79 was adjudged from his beliefs, from his intellectual capacity. If in the mains you get a question where, let's say, it's not a Nepali servant, but it's actually a doctor who's educated, who's smart, and in broad daylight he imagines that a person is a ghost, or he thinks that it's an apparition and kills, then you have to judge it from the intellectual capacity of the doctor. And in that case, this basic requirement of good faith might not be met. So good faith becomes the litmus test. Good faith becomes the foundation on which you adjudge the facts of the case. You see whether this person believed in good faith, and if you see that this person did not in good faith honestly believe certain thing and they still committed an offense, then it will not get the defense under Section 79. In another case, where the wife in good faith believed that her husband had drowned 6 years ago in a shipwreck, and after 6 years this wife remarried, it was held that Section 79 applies, that she in good faith believed that the husband was dead and she remarried. It is not an offense. She will not be prosecuted for having 2 marriages, because she was justified in good faith to marry again. This was the case of R versus Tolston. So good faith is the cornerstone by which you have to adjudge the acts of a person who's asking for a defense under Section 79. Good faith. It is important that person believes. So these are the bases of mistake of fact and mistake of law as exceptions under Indian Penal Code. If you like this video, make sure you subscribe so you get notified of future videos. And if you have any requests, leave them in the comments. See you next week.